payment that you can get at the bank, that's going to be, again, specific to that
Yeah.
account. And so it's really not going to address the whole issue of protecting your finances.
Right.
Okay, it's going to address one issue of somebody can pay your bills and deal with this one account, but it's not going to address the other pieces. When we do the power of attorney for finances, we have a lot of specific information that's in there that the agent is going to be authorized to handle on your behalf on your incapacity. And it can be as broad as you like or as narrow as you like. I usually recommend that my clients make it as broad as might possibly be necessary, but that leads to some concerns, you know, with the threats of abuse, financial abuse, and that kind of thing that might come up. So
let's go on from there then. So what kinds of things can the agent do with one of these powers of attorney?
So the most common actions that the agent is going to take care of are going to be bill paying, dealing with the IRS, dealing with Social Security, dealing with benefits, making investment decisions on your 401k and your IRA.
Maybe your investment account.
If it's not in the trust, right?
Yeah,
If it's owned individually. The other things that come up quite often is if you have a living trust and you did not manage to get your assets into the living trust before you were incapacitated, the agent can actually do that on behalf of the principal if the language in the document is there. So we can, even at that late date, take the steps to get the assets into the trust to avoid the later probate proceeding. So we can do some later planning to make sure things are lined up so that we're avoiding further administrative expenses down the road. The agent cannot change the beneficial interests on any accounts. So for example, if the elder, the principal, has an account that says POD son number 1, pay on my death, pay it to son number 1, and the agent is son number 2. The agent can't go in and change that beneficiary designation to say pay on death to agent number 2 or to agents number 1 and 2. So they can't change those beneficial interests. On the other hand, no, they can't unless the document specifically says that they can change those beneficial interests. But they never say that.
Okay.
They never say that. That would be too broad of an authority to give to your agent.
Now, related to some of what you were just talking about, though, there's actually been some cases related to this, that the power of attorney, if you want your person you're giving the power of attorney to be able to make gifts on your behalf, that you need to state that sort of a thing.
Exactly. That is not an automatically conferred power. It has to be specifically indicated in the document. And for example, the documents we draft in our office, there are 3 primary purposes why an agent would be authorized to make gifts. So when you're signing this power of attorney for finances, you're not just giving the agent the authority to say, hey, look, now I control the money. I'm going to give it to my friend here and my friend there, and I'm going to double pay the caregiver. And no, the gifts have to benefit the elder. They have to benefit the elder in some way. So for example, the agent could be authorized to make gifts for tax planning purposes. For example, the elder has a taxable estate, and we know that the elder would rather make gifts to the kids than pay the IRS. So we'll avoid paying taxes if we can legally do that. So we provide instructions that the agent can make gifts for tax planning authority.
Or possibly to specified family members, possibly
Exactly.
to take advantage of the annual exclusion for
Exactly.
the gifts, that sort of thing.
Exactly. So we'll do it for the tax planning, and it says who the gifts can be made to. Again, it's not just broad, you can give gifts away. It says, typically our documents will say to the, in the same proportions as to the remainder beneficiaries of the trust. So again, it's indicated who gets what amounts. A second purpose of the gifting is really for charitable and family purposes. So if somebody has a established history of funding KQED or some other nonprofit, or giving tithings to the church, or buying all the grandkids $100 gift certificates for the holidays, the agent can continue to make those gifts. Always the agent has to make sure that there's money enough to take care of the elder, and that it's appropriate to make those gifts. But if the elder had always made those $100 gifts to the grandkids every year for Christmas, the agent can continue to do that if the authority is there in the document, and it has to be specifically stated. So there are two. The third purpose is a very important one, and that is for public benefits planning. We can put language in the document that says that if I am catastrophically ill and my estate is going to be wiped out by my medical expenses, my agent is authorized to take whatever steps are necessary, including making gifts, to move my assets around, protect some for my family and relatives and loved ones, rather than having it all be exhausted for medical care, and then I still have to go on public benefits anyway. In my office, we do public benefits planning, but only in catastrophic situations like that, and that's where we put it, is in that document.
So when we say public benefits, you're talking about things like Medi-Cal planning and that
Exactly,
sort of
Medi-Cal planning for long-term care is where it typically comes up with an elder or somebody with ALS or Parkinson's or some debilitating illness.
Okay. So let's say I put one of these powers of attorney together. Can I change my mind? Can I nominate another agent, somebody else to be, if I don't like how this one's working out or whatever?
That's a really good question, Mike. These are revocable documents. As long as you have capacity, you can change your mind and name somebody else. Once you've lost capacity, you don't have the capacity to change it anymore. So be careful who you choose and put in the driver's seat. But absolutely, and in fact, it's one of the very common things that people come into my office to see me about, which is they've changed their mind about who they'd like to have on there as the agent. Because circumstances change. Maybe one child is now closer. Maybe the neighbor that they thought was going to take care of things has not been giving them the apple pie every week that they thought they were going to get. I mean, for whatever reason, they may decide that it would be better for somebody else to be named as the agent. It's very important, if the agent has already been acting under that document, that you go through formal procedures to revoke the existing power of attorney. If it's just a power of attorney that you signed as part of your estate planning, but the agent hasn't used it yet, then we'll just shred the old document and make a new one. But if your agent is actually already acting under the document and you've decided you can't trust them anymore, then it's very important they have to be given notice. You have to give all the institutions that they've been dealing with notice that the power of attorney has been revoked. Very important in order to protect your assets.
So one area of concern that we're talking about in our professional groups these days is financial abuse and elder abuse. So maybe you can talk for a few minutes about, couldn't this be used as a tool for financial abuse?
It has been, and it will continue to be used as a tool for financial abuse. And it's another really good reason that you should go in and talk with an attorney when you're setting one of these up. You're paying the attorney for their experience and their knowledge in dealing with these situations. They will counsel you and guide you and help you make the right decision about who is appropriate to name as the agent. And once you've determined who that person is, depending on whether it's your spouse, who you're very close to, or maybe it's just a longtime friend from church, and you don't have that close of a connection, that will dictate the breadth of the authority that you're going to give to that agent. And if we're really concerned because the principal, the elder, doesn't have a lot of other people close to them, we may even nominate an additional person who the agent has to account to report what's going on with the finances and to make sure that they are not misusing and walking away with the elder's funds. It's definitely an issue, and it's something of grave concern. and it's something we spend a lot of time counseling our clients about. But the two important pieces are know who you're naming as the agent and why, and put some time and thought into that. And depending on who that agent is, that will govern how broad or how narrow the powers are that the agent is given. If the agent abuses their authority, we need to know right away so that we can step in and help get action immediately. That's the kind of thing that we've got, you know, you get the DA involved, and you get the fast track team from the court involved to jump in and get the legal police protection going.
We probably have about a little more than 2 minutes left. How do you go about getting one of these and prepared, and what do people need to know about filling out this form and so forth, other than what we've talked about already?
Okay, so the form could be a single or double page form. It could be just a very, very simple, there's a statutory form where you actually just initial the lines of the authority that you want to grant to the agent, and then you sign it, and that needs to be notarized. You sign it, date it, have it notarized. Other forms, that could be a long form, it could be a 20-page attorney drafted form. It needs to be signed, and it should be notarized. The law actually says that if it's acknowledged by 2 witnesses, that the document is valid. However, your agent is really going to be unable to get a bank to recognize it if it's not notarized. So it's very important. The most difficult thing is for the agent to take that document to the bank and have it be authorized and recognized. So you want the form to be in good shape. You don't want a bunch of scratches out or scribbles or confusing marks on it. You don't want it to have been stapled and unstapled 3 or 4 times. And you actually want it to be a fairly new form. These get stale, unlike our other estate planning documents. If it's about 5 years old, your power of attorney for finances, I strongly recommend, even if you don't have changes to make, substantive changes, that you just go in to see your attorney and re-sign a new one. It will make it so much easier on the agent. So notarization, because that's what the banks are going to want to see, and that's what has to be on it in order for it to be recorded if real property is being dealt with. Okay.
Well, we're about out of time. Maybe you have a quick thought that you'd like to throw out to our viewers related to this as we wind this thing up.
A quick thought. I'll give a plug for Nolo Press. Can I give a plug for Nolo Press?
Fine.
Nolo Press has a lot of really great self-help legal books, and they have a couple that deal with powers of attorney for finance, durable powers of attorney. And if you would like more information, that would be a great resource. It's very reliable, and it's based on California law, and so you're getting accurate information. And they will give you pointers as to what kinds of situations you might have where you shouldn't rely on their book. You should go see an attorney if you have that situation. So it's a very good resource.
Great. Naomi, thanks for being my guest. It's always a pleasure having you here with me. Folks, hope we've given you some food for thought. This is a very valuable document that we're talking about here. Seems like there's not a whole lot to it, but as you can see, there is something to it. And so anyway, so again, we want you to seek legal counsel. Look up Nolo Press. See you next time, Financial Insider Weekly.